Director General of IPPAI has done me a favor by calling me after the time of the session is over by 1 minute, and therefore I can confine myself to a very short duration expression of my views. I should first tell you that I am still a student at the primary level so far as the power sector is concerned, either the technology of it or the commerce of it or the administration of it. I come from an altogether different field where I was since about 40 years to an unknown arena, and I am still trying to learn. So please excuse me if I falter. And then firstly about the cross-subsidy surcharge, we are living in a welfare state. And you know, the very basic document of our democratic functioning in its preamble has promised its people certain things. And as a part of the welfare policy which this country, our founding fathers have adopted, it will be inevitable to subsidize the supply of power to the economically weaker sections or such sections of the society which require the support of the state to prosper in their respective professions or occupations. As a necessary corollary or consequence, when a section of the society is subsidized, we have to find scapegoats for bearing the burden of those subsidies. Ultimately, the state cannot generate revenues from a vacuum. The state can generate revenues only from, again, different sections of the society. And therefore, it becomes probably an inevitable burden that has to be borne by those sections of the power consumers who, in the opinion of either the state or the regulatory bodies, who can afford to bear some extra burden in this regard. Maybe the state may be wrong, the regulatory commissions may be wrong, those who are appearing to be very prosperous may not be really prosperous. But you can't probably find fault with our impressions if you are meeting in a 5-star hotel in air-conditioned comfort and then speaking about cross subsidies, then as a poor or middle-class man, I would believe that these people can afford, they are only saying it if they can get some concession. And either as a public figure or as a judge, if I come to such a conclusion, I think I may not be wronged. I may not be found fault with. So cross subsidies, mind you friends, is a thing which may become inevitable for some more time till probably those sections of the society reach such a level that they can stand on their own legs, or the state reaches such a level that the state itself can provide the required economic support to such sections of the society to survive, or the distribution companies to supply power at a concessional rate or free of cost to those sections, the state reimbursing the distribution companies. Now we are in a very difficult situation. So far as Andhra Pradesh is concerned, you are aware, we have many problems which we inherited because of the division of the state. Right from the disputes we inherited in the power sector between the two states, as well as the difficulties in sharing the power which was produced, which is being produced in the erstwhile territorial area of the state of Andhra Pradesh. These things, of course, we are trying to surmount each of these difficulties, and I may tell you, because I found one of the topics to be about the pending matters which are before the APERC, and the booklet which is circulated to you, they have reproduced a circular which has been issued immediately after this commission was formed. The present commission was formed to know in which matters we have jurisdiction and in which matters we have not. If you are interested, I can tell you briefly about the way in which the commission may proceed in the pending legal matters, or if none of you have any legal matters, I don't think I need speak about them. But they introduced it as one of the topics in the session about the pending matters before the APERC. Anybody is interested or not interested? Because what is happening is, we are suffering from the not so well drafted legislation, the AP Reorganization Act, and the consequences it has ensured to various sectors in the functioning of the state. Particularly concerning the power sector, they tried to cover it in the 12th schedule. The 12th schedule stated that till separate SERCs are formed, the erstwhile commission will continue as a joint regulatory body for both the states for a maximum period of 6 months. To that extent, it is okay, nobody has any problem about it. But we have another section, section 105, which said that any matters pending before any authority, adjudicating body, etc., by the time of the bifurcation of the state, insofar as they exclusively belong to the state of Andhra Pradesh, state of Telangana, they go to the corresponding authority or body in Telangana state. Leaving the remainder, that is matters where the erstwhile state in its entirety might be interested, or where such issues transcend beyond the borders of the newly formed state of Telangana, leaving all those cases or matters or proceedings to be dealt with by the original authorities which continue in the state of Andhra Pradesh. Our difficulty is we do not know whether we are the original commission continuing as APERC, or whether we are a new commission which has been formed because of the 12th schedule. Because 12th schedule clearly says the existing commission will continue as a joint regulatory body till new SERCs are formed. So that, as you know, is an interpretative exercise which has to be solved by legal experts, and of course, finally not by us. Whatever opinion we may express in the cases before us, they will be tested before the High Court or the Supreme Court, and ultimately the judiciary at the highest level will decide which commission has to do which thing. And so much confusion has arisen in this. As I said, firstly, we do not know whether we are the original commission continuing as the residuary commission for the state of Andhra Pradesh or a new commission. And secondly, in many cases there are review petitions pending. The original order is relating to all the 4 distribution companies or the entire state. And now if I have jurisdiction only on the 2 distribution companies within the territory of Andhra Pradesh, I can review the order only to the extent of 2 distribution companies. Can there be a part review? Can our order remain as it is in respect of 2 companies and be changed in respect of 2 other companies? Will it be legally sound? That question, to my knowledge, has not arisen anywhere else so far. In what manner any review can be undertaken is also a question which is bothering us. And then the further progress in these cases also is so postponed due to various events. First, they said, some people said you have the jurisdiction. Some people said only CERC has the jurisdiction. Some people said in the absence of any trial forum, the appellate tribunal itself can directly take up these issues. That is their respective perceptions. Okay. Again, each of them changed their perceptions and came with the opposite version. Then, when everything is ready for hearing, It so happened that the standing council for the distribution companies, who was only one for all the four earlier, is now divested of two companies, and for two companies in Telangana, a separate standing council has been appointed. Therefore, I have to issue fresh notices to Telangana discoms to come before me and tell us as to whether they would agree that I have jurisdiction in those matters in which the entire state is involved or not. So this process is going on and may take some more time. But so far as matters in which orders were already pronounced by the erstwhile commission are concerned, there need not be a doubt. They continue to bind whosoever were parties before it, whether they belong to Telangana or Andhra Pradesh. Matters which were part-heard but not decided, including those in which arguments were heard and then orders were reserved or anything like that, if orders were not pronounced, they have to be heard afresh, because we have never heard them. They have to be heard afresh, and if we have the jurisdiction over the subject matter and the parties, then of course we will go ahead with deciding those matters. You know, these matters unfortunately will consume some time, and I could understand the difficulties of some of the parties involved whose stakes probably run to some crores of rupees each month, which is equally heavy even for the distribution companies also. But these legal proceedings, because of the technical reasons, we stand in a very delicate situation, and we are trying to expedite the things as far as possible to tell you what our view is as early as possible, so that the aggrieved can go to the High Court or the Supreme Court. Then the question of applicability of new wind policy to the projects commenced between April 2013 and February 2015. And then one more question. As per the new wind policy, banked energy is purchased by discoms or APERC. Relevant regulations are not yet amended. Insofar as the wind policy and solar policy are concerned, the government of Andhra Pradesh have issued the relevant government orders, which probably all of you know, and also requested the Commission, in exercise of its statutory power, to frame corresponding guidelines and regulations to implement the set policies which have been adopted by the state government. So the Commission is in the process of formulating the draft regulations. We have to invite public opinion on that, any views, suggestions, objections, etc., etc. We have also addressed even the power sector bodies, distribution companies, Transco, Genco, everybody, and the energy department also, as to what exactly they have in their mind about the scope of the regulations that have to be framed insofar as wind power or solar power or hybrid projects which are contemplated by the Andhra Pradesh government are concerned. And we are trying to put in a regulatory regime in place as early as possible. But as you know, these technical things take some time. When I give a public notice, I have to wait for 3 weeks, 4 weeks, then consolidate all the opinions received. Some of them may require a personal hearing. They may say, we'll come before you and personally explain and so on. And we are trying to put them in place as early as possible. And then about Transco and discoms charging the transmission and wheeling charges, which are said to be exempted for renewable energy as per the wind policies. I am not actually aware of the situation, and we will definitely go back and check up whether the wind policies prohibit the collection of such charges, and whether in spite of that the transmission corporation or the distribution companies are collecting such charges, and if so, an exercise of what power. We will try to verify that and remedy any wrong being done, if it is being done. Then about cost subsidy surcharge and the manner of its calculation, I should frankly tell you that we did not bestow much attention on the methodology of calculating the cost subsidy surcharge, and probably we followed the pattern being followed in the earlier years, because this time we are constrained in time and also the requisite expertise in preparing the tariff order, etc. Because the DISCOMs have asked for time more than once for filing the ARR and indicating their requirements and their demands for the new charges. And then after 1 or 2 or 3 extensions of time, we ultimately said either we file it or we proceed to decide it so motu as directed by the appellate tribunal for electricity in one of its cases. And then they filed them, and we have to conduct public hearings, and because it's a new state and we have to gather as much perceptions from the public as possible, we held public hearings at 4 places in the state and again in the headquarters, and we received more than 200 speeches and about 400 papers on various things, which we have to study, answer, try to comply where it is possible, and then prepare the tariff order. I should therefore confess that so far as the methodology of calculation of cost subsidy surcharge is concerned, I think we have gone by convention and not attempted to make any change. Cost subsidy surcharge may be factually high, but as I said, it is becoming inevitable when the Commission is burdened with the duty of balancing the financial health of the distribution companies, the welfare commitments of the state, and the paying capacity of different categories of consumers. So if I am hurting you, please excuse me, and I have added one more cup of coffee also to your expenditure to the cost subsidy surcharge. I thank you very much for giving me this opportunity.